All right. Hi, who do we have first?
Judge, will we approach on Michael Dillon or call him the record when Mr. Baker wants to do?
All right. Is there something wrong with the internet?
It wasn't earlier. Oh, I didn't have any caution checking. It took me a minute.
All right, this is the matter of State of Ohio versus Michael Dillman, case number B2103230. Mr. Dillman is represented by Mr. Brett Baker, Mr. Ted Peter, and Allison Oswald from the State of Ohio. This matter is now set for a status report. Mr. Dillman requested counsel, and counsel asked him to withdraw. So now we are with Mr. Baker, who's been appointed recently. Mr. Baker, what would you like to say? You want your client brought down from the Justice Center?
Judge, I'm fine with going forward without his purposes for today. What I had told him I would request of the court, what I am going to request of the court is a brief continuance so that I can get up to speed as it were. I have received some discovery from prior counsel. I'm going to evaluate that in the process of doing so. But having finished it, I want to see if I've got everything that there is, and then I would like to go over everything my client discussed, other options are from there. So I would ask for 2 or 3 weeks as request for it.
How long do you think you'll need to make sure you have all the discovery and meet with your client before the next court date?
3 weeks, Your Honor.
3 weeks?
I think that would be sufficient.
All right. Ms. Howard, can we get a date? State, what would you like to say?
That's all fine with us, Judge.
And we'll continue for a plea or trial setting at that time.
October 5th.
October 5th should be fine.
October 5th?
Just to-
Yeah, all right. October 5th, 9 a.m. Time wait.
Yes.
All right, so I'm making a note here that we're continuing this for 3 weeks to give counsel time to make sure he has all the discovery and meet with client. And then we should be ready to either plea or trial setting, okay? Thank you. All right, who's next?
Judge, will you approach sidebar on Dearest Cross?
Sure. Can you wear your mask and okay with me? Yes.
I spoke to Mr. Tierney about computer, I think he's gonna check on that with the new case. And some money as well.
Yeah, she is under the Colgate police when he was arrested with a computer that she says belongs to his girlfriend's work and money. And I said, I don't know about that, I have to ask him. As far as the computer goes, they would believe he would use any device that wasn't his in order to conceal who he is communicating, so they may have taken it for that reason. The money might.
Judge, I guess the bigger issue is that he got indicted with the attempted murder of the one of the victims. So now he's got two different people. The attempted murder, somebody already just been indicted for that. So basically what the theory is that Cross ordered the homicide or the murder of Leonard Wiston. That guy named Sanders is the one that actually did it. He's already indicted, Kevin Sanders, and he's indicted actually. He got indicted a couple months ago.
And who's the case?
That's Walter J. Tierney.
Okay.
So we definitely wanted to try those two together. Sanders has the lowest case number because he got indicted probably 3 months ago.
Yeah.
Or more.
Maybe
So he's up in here in this room.
So you're asking for the new case to be switched to Garrick, the pre-COVID case here?
That's what.
Because they really are separate, aren't they?
Well, the conflict, I think that evidence is going to be coming out that the reason that the hit was ordered was because they worked at the Tennessee drug case, that this was done to silence him from being able to testify that case number.
I
So
understand.
there is some connection between the two.
Yeah, no, I totally understand that.
And I know
Except
Clyde's
I
guy
know-
is going to plead out. So I didn't know if it was, go ahead.
But you're gonna have an issue with that in front of the jury, hearing alleged allegations of intent in a drug case, right?
Absolutely.
So it's two separate trials anyway. So that's why I'm thinking that the attempted murder and mutual should be hearing with the co-defendant. And this drug case, underlying case stay here. Do you all disagree?
Well, there's two things, Judge. Number one, as we all know, the elephant in the room is Mr. Riskin's health. If he
What?
is Mr.
Yeah,
Riskin's,
yeah, yeah.
if he were to pass away, we obviously be using a lot of things as far as his ordinance. But we haven't filed anything. We've taken a look into using some of the type of things that you're talking about in that trial. So the drug, I know what you're saying, that the crimes are separate, but it'd be disingenuous to suggest we're not going to be attempting to use some of that evidence that points to that kind of thing in the actual drug trial.
Yeah.
Especially if, God forbid, if he were to pass it, there'd be even more. But having said that,
Yeah, I understand. But I did.
and those are rulings of the court that we don't know the answer to right now, and we haven't filed anything, but it could go either way.
Yeah. I think that as long as you still. I think there are two different trials. Even if I took the cases, even if I brought Sanders' case here, it's two different trials, right? So that's why I think if Sanders having a lower case number, it has to go there. And the judge stays here, at least at this point. Okay,
I understand.
Are you gonna be asking on the record for?
We are,
this to be
Judge.
transferred? Okay. So, are you gonna check?
To the new case transfer.
Okay, so let's do that part today.
Okay.
And then, to put the DSC, get the hearing. And then the post-conviction, not post-conviction, what's it called? Pre-conviction case return, would just go along with the other case, the other case, okay?
And Judge, we would have said his, and then he's on your case. Not be revoked because of this new act that was committed, not by this new indictment, so that he's on that case. I'm assuming he's still locked up there.
Yes, and I would just ask that we put those arguments on the record if that's what you're going to request.
Okay, do you want to write down for that?
Well, I don't know whether he's upstairs or not, but I would like to file something in writing if that's what you're asking. If you're asking the court to revoke his bond.
Sure, we can find something right in
We'll
there.
do that.
Okay, all right,
Thank
do
you.
that, all right, thank you. Are you ready to go on the record?
This is the matter of State of Ohio versus Darius Cross, case number B 2002020A and B 2203946. These cases are on today for pre-conviction case return and DSC. State, what would you like to say with regard to the DSC and B?
Judge, with the DSC on the new charges, there was somebody else indicted for the same set of facts and circumstances, Kevin Sanders, that's rolled to Judge Gehring. That case has a lower case number than this case number, so we are asking for the new case number of Darius Cross to be consolidated in Judge Gehring's room to be tried for Kevin Sanders. We have not talked to Judge Gehring to see whether he'd accept that. We wanted to talk to you first to see whether that was okay with you. If you say that it's good with you, we will go and talk to Judge Gehring to see whether he would accept it.
All right. And so that this new case is not an A or B number, so they're literally two separate numbers, right?
Yes,
It's
sure.
just that Mr. Sanders has a lower number.
He does.
I see. All right, any objection, Ms. Underwood?
No, Your Honor.
All right, so I would be, willing to transfer the case of B 2203946 to Judge Gehring with Mr. Cross's co-defendant if Judge Gehring would accept it.
Yes, sure.
All right, and so you'll have to let me know if Judge Gehring will accept the case, and then we can make that transfer. With regard to, and Ms. Underwood, do you want your client broken down?
No, Your Honor, I'll wait his presence.
All right. With regard to the pre-conviction habeas return, it looks like this is a violation of his pretrial release because of the new indictment. Is that your understanding?
That's my understanding, Your Honor.
All right. And how do you want to proceed on that? Do you want to proceed on that today, or do you want it to be continued with the other matter?
I would not like to proceed today, Your Honor. I would like to file something in writing to what I believe the state's request is going to be, and then set that for a hearing.
All right. State, are you going to be making a request?
Judge, we are going to be making a request for his bond to be revoked. The prior bond that the court set in the drug case, for various reasons that we can either lay out today or we can do it in writing, and then let Ms. Underwood respond in writing and then we get here, whatever the court prefers.
I think it would be preferable to have the state just, briefly put in writing their request and then give Ms. Underwood an opportunity to respond. Let's put this on, we have a jury trial set. I have not set a final pretrial because we've had a final pretrial in this matter with the co-defendants previously. But let's just set this one case, the A number, for a status. if we can get it in sometime between now and October 11th, the trial.
We could do, October 5th.
October 5th is bad for me, it's a Wednesday. I can do the 4th.
All right, we'll do a status report, October 4th, 9 a.m., time wait.
Yes, Sean.
All right, is there anything else, Ms. Underwood, with regards to Mr. Cross?
No, Your Honor.
All right, Steve?
No, Your Honor.
All right, so I will, right now, put them both numbers on October 4th, with the understanding that as long as Judge Gehring accepts the transfer, we'll transfer the new case out.
We'll go to the CMC judge.
All right, thank you very much.
Thank you, Your Honor.
All right, Madam Prosecutor, who's next?
Judge, we can approach on, Jones, please?
Shopper Jones?
Yes.
All right, can we, just call that one then?
Yes.
All right, this is the matter of State of Ohio. Versus Shopper Jones, case number B2200469 and B2106477. This matter is set for a jury trial today. Mr. McCluskey is present on behalf of Mr. Jones, and Ms. Kristen Kiefner is for the State of Ohio. Mr. McCluskey, where's your client? You want to brought down?
Judge, I'm willing to waive my client's presence. It's my understanding he's refused to come over from the jail this morning, however.
Do you know why?
I do not. I spoke with him on Friday, and everything seems fine, so I'm not sure what the issue is.
Ms. Howard, do you know why?
They didn't say they just refused to come over.
All right. I have a motion to continue the trial date for today, Mr. McCluskey.
That's correct.
Speak on that?
I did, Judge. We filed this last Wednesday. I'm Mr. Jones' second lawyer. We were in possession of some body camera footage that we had been watching. In doing so, it came to my attention that for whatever reason, one of the links wasn't working, so I had to have that sent. I need an opportunity to review this in depth, and I need to watch it with Mr. Jones. He had raised some issues with me that he felt were pertinent, and in watching the body camera, I'm not sure, there may be a motion to suppress issue in terms of the search of the house and how that was conducted. The body camera I'm in possession of right now, however, is unredacted. So I don't know if there's a redacted version that I can share with him, because I think he needs to see the body camera. I think he has a right to understand all the state's evidence before he makes a decision on how he wants to proceed. So we're just looking for some additional time to get that done.
All right, when did you receive the body cam evidence?
I think it was sent to me in August, but apparently it went to a junk folder, and I didn't realize that's where it resided. So I got it about a week and a half ago and downloaded it. But one of the links on one of the videos, which is the longest video, and I think probably the one that my client's in, is not working. So I asked Ms. Keeper to reset those, and she did that last week. And talking to Mr. Jones, I know he wants to see them. I think it's important he does that as well.
So, Stacey, anything you want to say?
No, Judge, I don't have a redacted writing here, and that's something that he's gonna need to show to his client. We would have to contact records and see if we can do that on the, list of videos to redact so that he can show it to his client.
Well, today was set for trial, so wouldn't you be playing unredacted videos at
I
trial?
have the unredacted.
Oh,
But he's not,
you need to redact it.
Yeah.
I see. And you've seen the unredacted.
I've seen the unredacted, and I do have some questions. Mr. Jones had raised an issue with me when I first met him about his interaction with the police related to the search of his house. And when you watch the unredacted version, the version I've seen, that kind of plays out. And I think there might be a legitimate suppression issue. Like I said, there's one video I can't see, and I don't know what's on it, but I believe my client is on it, so I'd like to know what's happening and what's said, because if he says something that's not good for him, okay, that's different. But if there is nothing, then I think this other issue comes into play.
And, this is the first time I'm hearing about any potential motion to suppress. I would assume that the council had the unredacted videos as well. Ms.
Judge, they did.
I asked Mr. Jones about it with his other lawyer, he said his other lawyer didn't see it that way, so.
I see. All right, how much time do you think you need?
Judge, if I give you 30 days, I can probably have it all resolved. Have an idea of what Mr. Jones wants to do, and if he wants to go to trial, we'll reset it.
Oh, you're asking the
I'm gonna
days?
ask for 30 days for a pre-trial report, just to go through the body camera with him. If there's a motion to suppress, I'll need to file that. And then we can decide where we go from there.
Well, I will say that, time is of the essence here. Mr. Jones has been incarcerated 263 days. We have reset the trial 3 times, not due to you, Mr. McCluskey, but this is the 3rd time we'll be resetting the trial. So let's continue, the matter for, will you know in a couple of weeks whether you're gonna file a motion to suppress?
Yes.
All right, let's set this matter, what's the first available we can get, Ms. Howard, we're in October. When was the first available we can get?
We go 30 days, October 12th. A week before that.
All right, October 5th?
October 5th is a very crowded day. How about
4th?
When is that just for,
Status.
that's okay.
we can make the 4th work?
All right, the 4th at 9? Time waived?
Yes, please, Judge.
All right, so then we will come back on the 4th at 9 o'clock. And, by then, we'll know whether or not you're gonna either file a motion to suppress or we'll reset the trial.
Thank you very
All
much.
right, all right, and, at this point, you're not having issues with your client, I'm not sure why he's.
No, I don't, I'll be honest with you, he and I seem to get along fine, and like I said, I talked to him Friday, I had no indication. I don't think this really has anything to do with me or the court, I'm sure it's
Okay,
something in jail.
all right, thank you very much.
Thank you.
All right. Mr. Keeper. You ready?
I'm ready for Mr. Ellis whenever you brought it out.
We'll call down. Alice?
Oh, yeah. Judge, we can call Leandra Glenn if you are ready.
You want to drop down?
No, but,
All right, this is a matter of state of Ohio versus Leandra Glenn, case number B2103303, B2102474. Mr. Glenn is represented by Ms. Angela Glazer and Mr. Bradley Fox, Ms. Libby Paulson for the state of Ohio. I should say Mary Paulson for the state of Ohio.
it's Mary Elizabeth, Judge.
I'm sorry?
Mary Elizabeth.
So, okay, so you go by either?
Usually I will say Elizabeth,
I see, all right.
whatever the court.
That's what we're gonna say, right? All right, Elizabeth Colson for the state of Ohio. This is on for a status report of these two matters. Council, where are we, and what would you like to do?
Judge, I believe we had this just marked for a status report. We do have all of the discovery from the state, and we have a trial date already set for December 5th. So we're in a good position right now.
All right, so you have discovery,
Yes,
you're just reviewing your client and mounting your defense, and we're on track for the trial.
yes.
Let me see, when is the trial, December?
December 5th.
All right. Anything from the state?
Judge, I would just note, that I have called the hallway multiple times for Honesty Jones, who is the victim's representative, and I have not seen him this morning.
All right. Well, I don't want to continue this until December, so let's get a, would it be helpful to have another status in about a month or so?
Yeah, sure.
All right, let's do that.
October 12th.
October 12th?
Yes, that was-
That's good, Your
All right. You waive your client's presence for today?
We do.
All right. And then the next, hearing will set a final pre-trial conference, okay? Thank you for your time.
Yes, we do.
Thank you so much. All right, who's next? Madam Prosecutor?
Are you ready for that?
Not yet.
Are we ready? You guys have come out?
Question. We're good, Judge.
We good?
But I think Carrie should, but I want to go back to that. And she wants to go. You guys.
You're regarded.
That's great.
Yeah.
May I see it?
Like us to approach, Judge?
No, not yet, I'm on paperwork. All right, can I see counsel on the sidebar over here today?
Yes, Your Honor. I'm sorry, let me get a mask. Yes, yes. Good morning, sir. Good morning.
Should we try to correct one from another courtroom? Sure. I'll go get it. What's that? Judge Wagner.
Same kind of did and then it has to go off. The low end of the very much, so I was even with that PSL had asked them to stay in pending stuff.
All right, we will recall Chambers in order to get the form, the correct form.
Please turn your phones off.
We're ready to have Marvin Lear if you're ready to do that. Morning, Judge.
Good morning. All right, this is the matter of State of Ohio versus Marvin Lear, case number B2105646. Mr. Lear is present in the courtroom with his attorney, Ms. Anzia, Ms. Kristen Keepner from the State of Ohio. This matter is set for sentencing today. Mr. Lear, having entered a guilty plea on an agreed sentence recommendation on August 4th, 2022. The matter was set over today for sentencing. PSI was waived. And there is an agreement on the recommended sentence, which the court is prepared to honor. Is there anything you want to say on behalf of Mr. Lear, Ms. Panzika?
Judge, I believe at the last setting, not only did you hear from myself, Mr. Lear, and a few of his family members. So I'm just going to reiterate, it sounds like the court's willing to follow the agreement to the sentence.
All right, thank you very much. State?
I'm gonna check, you just asked me if you want to read my recommendation.
The court has considered the overriding purposes of felony sentencing. Well, before I do that, Mr. Lear, let me give you an opportunity to say something if you want to say something additional. I know the last time I heard from you, you were very passionate about your family. I heard from your family, and if there's anything you want to say today, I'm willing to listen.
I don't need to say that if you look at the factors of 7 years of probation, was considered.
Well, you've agreed with the state to make a recommendation to the court that you serve 5 years in the Ohio Department of Corrections. I understand what you're saying today, but I just want to remind you of your negotiation and your negotiated recommendation to the court, and I'm going to follow that. Okay? The court has considered the overriding purposes of felony sentencing pursuant to revised code 2929.11, which are to, number one, protect the public from future crime by this offender and others similarly minded, and two, to punish this offender using the minimum sanctions that the court determines accomplish the purposes without imposing an unnecessary burden on state or local government resources. I have considered the need for incapacitation, deterrence, rehabilitation, and restitution. I've also considered the joint recommendation of the parties. I have recently calculated this sentence to achieve the two overriding purposes of felony sentencing and to be commensurate with and not demeaning to the seriousness of this offender's conduct and its impact on society, and to be consistent with sentences imposed for similar crimes committed by similar offenders. I have also considered the seriousness and recidivism factors as set forth in revised code 2929.12. Accordingly, Mr. Lear, I imposed a jointly recommended sentence of 5 years in the Ohio Department of Corrections. That's 12 months on count 1, 5 years on count 2, to be run concurrently with one another. The sentence on count 4, which would be 5 years, but it is actually merges with count 2. I have been presented an affidavit of indigency, which the court is prepared to execute and accept. Therefore, fines and costs will be remitted. I want you to know that there is a mandatory post-release control period on counts 2 and 4, which is 18 months, a minimum of 18 months, up to 3 years. The post-release control time on count 1 is discretionary, and it may be up to 2 years. Is there anything else, council?
No, Judge.
Judge, you did order the forfeiture of the firearm on August 4th, but I didn't know if you needed to order again today for the entry or.
All right, thank you for the reminder. Yes, the forfeiture of the firearm will be issued, and I think that was an agreement by the parties as well, correct? All right. All right. Mr. Lear, you have a right to appeal your conviction and sentence. Should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you at no cost to you. Do you understand?
Yes, ma'am.
I wish you well.
Thank you, Judge.
Sorry.
You're fine.
Are we ready, Mr. Tiffin?
Yes, sir.
Turn it on to see what the view is. You can like put the camera back on. View is.
I'm not sure. There's a view right there, Judge.
It doesn't look like it's. Okay, great. Thank you. This is a matter of State of Ohio versus Solomon Ellis, case number B2203-064. Mr. Ellis is present in the courtroom with his attorney, Mr. Tippin, Ms. Keepner for the State of Ohio. This matter is on today for a clear trial setting. And I know there is also a motion to reduce the bond. Counsel, what would you like to say on behalf of Mr. Ellis?
Thank you, Your Honor. The main thing is Mr. Ellis has no criminal record at all that I can see as an adult or a juvenile. We do understand this is a serious charge. However, from what I've seen in discovery so far, he was initially charged with complicity. The only allegation we've seen in regards to Mr. Ellis personally is that he was alleged to have been a passenger in the car after the fact. But Judge Dickon, no record at all. He can make some bond. He is also able to do electronic monitoring if the court would consider reducing the monetary amount. That's the big hindrance at this point, is he just can't make the money bond. I know I put in my written motion 30,000 to 10% would be doable. Since I filed this, he has indicated in talking to his family that ideally 10,000 to 10% would be makeable for him, but obviously we would appreciate any reduction to the bond. Your Honor, he would be living here in Cincinnati with his father. His father's also the general manager of IHOP. That's where he was working before being incarcerated, and believes with his dad being there, that he would be able to get that job back if he is released, and is able to do that on electronic monitoring. So Your Honor, that's what we're requesting. He is a lifelong resident, high school graduate. Main thing is his life record.
All right, thank you. State?
Judge, we did contact the victim in this matter regarding the bond reduction. Since she guys live 2 hours away, she did just email us back and not come today. She was in opposition of the bond being lowered. She is concerned with the safety of her children, her son, but her children. The victim in the back seat of the car was a 13-year-old male. The firearm was admittedly not by Mr. Ellis, but by the code amendment pointed at this child when he's ordered to get out of the car, and both of them get in the car together. He did admit to the police that the two of them walked around to several different gas stations in an attempt to kind of see which ones would be less populated so that it would offer them a better opportunity to steal the vehicle. So it's not that he was just there and got into the vehicle. He admitted to criminal involvement prior to the stealing of this car as well. So we would ask for the bond to remain the same.
All right, Mr. Tupin, you indicated that in your motion that Mr. Ellis can live with his father. Have you confirmed that? Is he here today?
Your Honor, no, it was confirmed by pretrial when he was first brought in. That was in my paperwork at least, that they have his address, the same address he gave me, the same name he gave me.
That's where he lived anyway.
Correct, that's what he was living there before this.
Oh, I
So
see.
he returned to the same place he's lived. We lived there for a while.
All right, the current bond is 50,000 straight. All right, I'm willing to grant the reduction in the bond to 30,000, 10% with GPS EMD monitoring, and stay away from the alleged victims. We have a trial date October 11th. Are we on track for that trial date?
Your Honor, the big piece I'm missing at this point is most of the allegations and information contained in the informal discovery I have seems to be a summary of a statement that Mr. Ellis allegedly made. My understanding is that took place in an interview room and there should be a recording of it, but I have not received that. And I think from what I have seen, that seems to be a pretty important part of the case, if not the main piece of evidence. So it's hard for me to know where the case is heading until I have that, to be honest, because I think that's going to answer a lot of questions.
All right, Steve.
Judge, I have reached out to the officers, and then I don't have the particular detective's personal number right now, but I'm working on it, and so we can get that back specific about that.
Yes, we're gonna need that, because the trial is October 11th, which is a month from now. If that's, we'll be coming back asking to continue the trial, he doesn't have that, which I understand. So, all right, let's go ahead and set it for a final pretrial conference, in October. Trial is October 11th.
October 6th.
That works for me.
That's good. October 6th at 9 a.m. All right, time waiting till the trial.
Yes, Your Honor.
All right. Anything else?
I don't think so this time.
All right, anything from state? Good. All right, thank you. All right, I'm not sure who's next. I have 3 lawyers in the room, but I'm not sure who's next. This is the matter of state of Ohio versus Tyrone Weatherspoon, case number B 22-03072. Mr. Darren Nye is present for Ms. Witherspoon and Ms. Kristen Heathner for the state of Ohio. Mr. Nye, this is a clear trial setting. Your your clients in the Justice Center, do you want to brought over?
I don't, Your Honor, and I let him know that we probably wouldn't bring him over. What we're waiting for, we have a trial date, we've not been time, and there is a video that we believe will tell us one direction very clearly or not. This is my client going into the residence that we are unfortunately still waiting for. And I know the prosecutor has told me that she's reached out numerous times to try to get that video. My client has shown still photos at some point in this process. I would like to see them, just because we have a trial date on October 11th. My client anxious to see them also.
All right, state?
Judge, I have drafted through our discovery agreement to attempt to get those videos, and we're still getting on them, and I can, email here today, which I'm working on.
All right, so we have a trial date a month from now. And the video that the state intends to rely on, that I may or may not identify your client, the state doesn't even have yet, despite best efforts. If you file a motion to compel, you can do that, and we can address it.
Right.
If that would help the process. But, we'll allow the state to go ahead and make one more attempt to try to get the evidence, before the trial date. And, let's go ahead and set, final pre-trial.
10/6.
October 6th.
All right.
Can you do that?
I can, Your Honor.
All right,
Thank you, Your Honor.
9 AM. The time is not waived, but we have until the trial date, October 11th. Okay?
Right. Thank you, Your Honor.
Thank you. Yeah, this is it.
Okay, I'll be right there.
This is here.
Coulter?
Oh, it's in the
Yes, ma'am.
Oh, thank
We put them down. Yes.
But I should tell you, he's soccer citizen, and that's why
He what?
he put the calls from soccer citizen,
Oh, yeah.
and he doesn't want to be represented. Or he doesn't hold down that jurisdiction and all that.
Okay, okay. Can I ask you about other people? You want to talk before we go? Yeah. Sorry, Mr. Rivera.
Ms. Howard, can I get a copy of the probation violation of Coulter? I didn't know this is.
Sorry.
What's the, this is the.
Yes. No, but she meets and greets. Because it's already said. Meets. Yes.
Well, Detective Zaki, is that for sure what the web's operating?
Yes.
No, for sure. What it says.
Yes. That's the
Mr. You ready for call? And then you want her.
I'm sorry. Yeah.
Is this for me or you want to give it back? Is this for me or do you need it back?
No, it's for you.
Yeah.
No.
No, maybe.
Yes.
Yes, that's it. And one person. Time to go.
Okay, great, thank you.
You're welcome.
That's okay. So, just
Was that just,
Be home careful and sit down,
It's the adults.
supposed to be there, so 3 months, at least 6 months.
Hey there. Okay.
Were you on that too, Jones?
That can't be.
We're gonna be scared, so we're gonna address it with her on her as soon as possible. They're getting out of here or arranging a order that we make for trial.
Mr. Cameron, Mr. Net, Mr. Jackson. Ready.
My phone's been brought down.
All right.
I missed that.
Mr. Jackson, will go first.
Just, you want me to bring my client in?
Let's see.
It's a trial.
Yes.
Oh, I don't know. I'm sorry, I'll be right back.
All right, this is a matter of State of Ohio versus James Underwood. Case number B 2201-306. Mr. Underwood is present in the courtroom with his attorney, Mr. Jackson. Ms. Keepner for the State of Ohio. This matter is set for jury trial today. All right, Mr. Jackson, you ready to proceed? I think I received a motion to continue.
You did, Your Honor, and we filed that motion on September 2nd, and the court was going to be out the previous week. We were trying to get it in before Your Honor left for the week. There was an issue, we were served with a DNA report some days before then, I'd say a matter of maybe 3 or 4 days before I put in the motion for the continuance. But in the meantime, we also learned that there are pending labs for ballistics reports. So
For what?
a ballistics report, Your Honor, in conjunction with this case, there was a search that was done on my client's fiance's apartment. That is where the DNA comes from, the firearms that were seized during the course of that search warrant. But also there was, again, a ballistics report, which could be either inculpatory or legal exculpatory. And so we're asking the court to grant us a continuance if there is evidence that still is out there that may very well factor into my client's case.
State.
Judge, that's accurate. We did serve them in August with the DNA lab, but there are still a ballistics lab that is outstanding and still pending that I do not have.
My understanding, Your Honor, is that this was not, it hasn't been processed in the lab yet. Detective Zaffi has kind of communicated that to both of us, Ms. Keepner and I. So because of the search and because of the connection that I believe the prosecutors are trying to make to these firearms, we definitely would like a copy of that ballistics report. I feel it's necessary, Judge.
All right, so two reports that are needed, the ballistics and the.
I did receive a DNA
You
report.
did receive the DNA report?
Right, that was just days before I filed the motion to suppress it. So Mr. Underwood and I haven't even sat down and talked about it, much less determined whether he wants to hire a DNA expert of his own to analyze this. Again, the allegation in the DNA report is that his DNA is on some of the firearms that were seized. My conclusion is they are trying to speak for the prosecutor.
So you already have a report that says some DNA is on the firearms.
On the firearms, but.
And the state is still wanting this ballistics.
Judge, I know Mr. Jackson asked me if there was a ballistics report that existed. I was unaware that there was. I checked and saw that there was one pending. I reached out to the detective. He informed me that that's the ballistics, so that would be like case of the comparisons to the gun. I do not have that. So if he wants that, I don't have that at this point. The DNA lab was served weeks ago. As soon as we got it.
And so Mr. Underwood and Mr. Jackson haven't had time to talk about what they want to do about the DNA evidence.
That's correct, Your Honor.
How much time do you all need?
Well, we need more time, Your Honor, but I think that well, here's the problem. My estimation is that the reason why these guns are an issue is that they're going to try to say this was a firearm, at least one of them, used in shooting Mr. White. Again, the ballistics report could be as culpable. I asked Ms. Keefer, once I received the DNA, is there a ballistics report out there? And she informed me that there is one. And so we definitely, even if.
Exculpatory on the felonious assault?
Correct.
Okay. But not necessarily for the having weapons involved with disability, because you already have a report saying his DNA is on it.
We have a report here. We may wish to challenge that report, but I think the probably bigger issue, and obviously the more serious charges, are the felonious assault. That is something we would need a ballistics report to show if there is a nexus or if there is not.
Okay. All right. I understand. My only question remains, certainly we need the ballistic report for need the ballistics report. Got that. But how much time are you gonna need to talk about whether or not you wanna get a DNA expert? Because, see, the court, you guys had time. So I'm trying to figure out why you haven't already talked about that. And how much more time do you need to talk about that?
Well, Your Honor, even if we had identified a DNA expert, had them issue a report, we still have to give it to Ms. Keefe. Mr. Underwood and I will talk as soon as we leave here, Your Honor, is willing to bring us to the table. So we will make that decision today. If there's some issue with retaining a DNA expert, that needs to be addressed, and I will address that with the court, obviously, in the motion also to.
All right, so I'm willing to continue, but now I need to know how much time you're requesting that I continue it to. Because I'm gonna tell you what I'm thinking, you probably not gonna like it, so I wanna hear what you think.
Well, Your Honor, I'm not, since Detective Zaffi is here, I don't know if he has an idea of when we would have the list report. But I would ask for at least 30 days just to see if we can get that report. Unless Detective Zaffi thinks otherwise.
Okay. Well, that's where I was too, 30 days actually.
No, Your Honor, we have a presumptive match of the gun, ballistics match of the gun, through ATF. It is then sent to the Hamilton County lab. They don't have any idea, but I can call them and request that it needs to be done by a certain date, and see if they can get it done by that date, if and when you want to coordinate.
All right, so right now, you have a presumptive match. Mr. Jackson didn't even know that, did you?
Does not.
Okay, till this month, all right. So, but I know you want the official.
Yes, sure.
So you're entitled to that. So, let's go ahead and see if we can, get a date in 30, 45 days for trial. So the defendant's motion to continue the trial date is granted. Will time be waived?
Yes, sure.
I will tell you, October is a little tricky. She may be able to find something, she may not.
Yeah. It seems like Ms. Howard should have hit.
I'm looking at, November the 7th.
November 7th,
You know what, that's the day before.
it's all right. We can take a break. November 7th?
That would be fine with me. Your Honor.
All right, let's do it then. All right, November 7th. That work?
Seems to work good.
All right, November 7th, 10 a.m. Now, Mr. Jackson will continue the trial date to November 7th. I'm not really concerned about another final pretrial because we actually had one of those. But I do want to make sure that, we're on track to have the report that is needed. So do we need a status report or are we okay? Are you okay to just keep it for the 7th? And then if you don't have what you need, we bring it to the court's attention before then?
I can do that, Your Honor.
All right, is that, all right?
That's perfectly acceptable.
Okay. All right, let's do that. We'll just continue the trial until, November 7th and at 10 a.m. And then if there's anything that comes up before then, either side, you just bring it to our attention. All right? All right, anything else, Mr. Jackson?
No, Your Honor, thank you.
All right, anything is, all right, thank you very much.
Thank you.
Mr. Coulter. All right, this is the matter of state of Ohio. Yes, I know. Versus Dennis Coulter, case number B 2001845. Mr. Coulter is present in the courtroom with his attorney, Mr. John Cameron, who has been appointed, and Ms. Kristen Keeper for the state of Ohio. This is a probation violation, and counsel, did you get an opportunity to receive the probation violation and go over with your client?
I did receive the probation violation, but I was not able to.
I'm here about special appearance, I'm authorized, we can't write this off.
Wait, hold on. Put your mask back on. Hold on. That's the last time I'm gonna tell you to hold on, okay? All right.
Your Honor, what I was saying was I have received a copy of the probation violation report, and then I went to Mr. Coulter to discuss with him. He indicated to me that he does not want me to be his lawyer. He wants to represent himself.
Oh, okay. Is that accurate, Mr. Coulter?
I'm here by special appearance, I'm the authorized representative to the defendant with the third party agreement with vested interest.
Can you pull the mic down? I can't hear you. No, don't pull your mask down, so pull the mic down.
I'm
Okay.
here by special appearance, I'm the authorized representative to the defendant, I'm the third party intervener with vested interest in the outcome of the defendant's case.
Okay.
As I want to see the oath of affirmation on the bottom of this case, I want to look at support of competent jurisdiction, I want to look at support of 3/4 or 1.
Who's the defendant?
The legal fiction, and I'm not answering no questions, I'm only answering the questions I have for jurisdiction, and y'all have no idea, I'm no dismiss.
Okay, so Dennis Coulter is the defendant.
No, I'm not,
And are you Dennis Coulter?
No, I'm not.
You're not? Well, who are you then?
You refer to me as number one.
Number one?
Number one.
A noble one. All right.
It's not me.
All right. Well,
I want to see 10 for the tax on person to have this case. This is bond. What's your jurisdiction you have? On your things, blood pressure you have.
all right, so I'm looking at the picture of the person of Dennis J. Coulter. And the person I have standing in front of me is the same picture, but he wants to be referred to as the noble one. Well,
Is that
the
this?
noble one has.
Coulter of the Coulter family?
All right, so the noble one has a probation violation. And do you want to represent yourself or do you want a lawyer?
Not represent myself, I'm not the one that's charged. Legal fiction, all capital name is, he assumed it's look like that name, I'm not that name. All capital name is not me.
All right, Mr. Dameron, how do you want to proceed?
Oh, well, since he doesn't want me, I would ask you to withdraw.
All right. Do you want him to withdraw?
I don't know, I don't know who he is, I don't know that man, I have no contract with him.
He's a lawyer that I have appointed to represent you. Do you want him on your case or not?
It's not my case, I am not the most charged. You asked me, what is the all capital name, how would you use the word person today?
All right.
Right back.
Well, sir, you're gonna stay in the Justice Center until we figure out who you are
Well, I'm the United States
and how you want to proceed with your case. So, we'll continue this for 3 weeks, Ms. Howard.
You know, I will bring charge of property United States Code 1842, I can't bring charges on y'all, and give you notice, I will bring them on.
Thank you. October what?
October 4th.
October 4th, 9 a.m.
Call.
Ask you my motion to withdraw?
Yes, your motion to withdraw is granted.
ask for the update.
Thank you, Your Honor.
Thank you.
Legal fiction. For,
Sir, if there's any paperwork you want to file with the court, you may do so.
no.
Wednesday, Monday.
Yeah, it is.
All right, Mr. Chambers, Mr. Chambers, yes. Mr. Lewis, I think, filled the paperwork out correctly, but on this count 4, I think the max
Is it? I thought it was, if I could approach you, I'm sorry, I don't have my mask.
half of.
It was already the highest
I
part,
think it's the
highest
highest.
level charge.
Yeah.
If possible, apply it now.
Correct, that's
Yeah, but you don't have to put.
for the second. We'll do whatever the court tells us to do, but we believe it was only to the one count, not the lesser count, doesn't have the regular dose application.
Okay, I just want to make sure that he's advised of all this, so if I don't need to do that, it's fine, I just want to make sure the records.
I think the lesser count would have
Ready to toast.
regular toast, but it would only be applied to the
Right.
count 1, but not to.
That's correct, I mean, I have to notify him, so.
I know it's made to attach.
Yeah. That's right, then the aggregate will still just apply to the one. And he was, I'm sorry, Jeff, thank you.
Correct.
We discussed that.
All right, for a second. Can I see council for a second?
Yes, sir. That's why.
No, well, to some extent.
My bad, makes pretty much.
It should be three.
Three is the most you can get.
That's what's so confusing.
No, separate. Can I ask you all another question? What's the cost of what she says for the website? $11 plus. 11, could be 11 plus 8.
Plus the
19.
16.5 plus.
That's what's confusing.
No, it would be 11 plus 8. Then you can add 4 or 5 after that. So it would be 19 plus 24. Okay.
Okay, but now we can talk about the minimum. Is it 3 or 4.5?
It's 3 to 4.
3 to 4.5.
Oh, can I see this, Jay? This is my concern. If I'm putting some hard
Sure, yeah, I don't, it's 3 minimum, but the 4.5 that much. Still, it's the minimum tax. That's what.
Okay.
We're all learning yourself.
Thank you, Jay.
All right, this is a matter of State of Ohio versus Raymond Chambers, case number B2105959. Mr. Chambers is present in the courtroom with his attorney, Mr. Lewis. Mr. Lewis, can you move that podium in the middle a little bit?
Is this better, Judge?
Yes, Mr. Lewis is present for Mr. Chambers, Mr. Nick Crosswell, and Seth Teeger for the State of Ohio. This matter is set for a plea today. I have been handed plea documents. And is this how your client wants to proceed today, Mr. Lewis?
It is, Your Honor.
All right. Is this how you want to proceed today, Mr. Chambers?
Yes, Your Honor.
Are you the Raymond L. Chambers named in this indictment?
Yes, Your Honor.
How old are you?
32. 32.
How far did you go to school?
Well, I got a college degree. Master's in human resources.
All right, just put the mic all the way up. Yeah, just.
A little different between the last watches, but.
Yeah. All right.
Hearing that.
Yes, I can hear you well, thank you. So you're able to read and write the English language well?
Yes, Your Honor.
Sir, have you ever served in the military?
No, ma'am.
Are you a U.S. citizen?
Yes.
Now, Mr. Chambers, I have in my hand 2 documents. One is a waiver of trial by jury, and at the bottom there are signatures. And I recognize Mr. Lewis's signature here. Is this your signature here, sir, where it says defendant?
Yes, Your Honor.
This is an acknowledgement by you that you understand that you have a constitutional right to a trial. But when you sign this form, you're saying, I understand that, but I'm waiving or giving up my right to a trial. Is that your understanding of what you were doing when you signed this form?
Yes, Your Honor.
Did you sign this form after consulting with your attorney about your constitutional right to a trial?
Yes.
Do you have any questions whatsoever about this form?
No, ma'am.
Do you have any questions whatsoever about your constitutional right to a trial?
No, ma'am.
I also have in my hand a entry withdrawing plea of not guilty and entering a plea of guilty. It's a 3-page document. On the 3rd page, there are signatures. I didn't recognize it. I don't know whose signature. This is Mr. Oh, okay. Yes, I do recognize the prosecutor's signature here. That's Mr. Croswell. I recognize Mr. Lewis's signature here. And then here, sir, is this your signature?
Yes.
All right. Mr. Prosecutor, would you please put on the record the party's expectation regarding this plea?
Your Honor, our understanding is that the defendant will change his plea from not guilty to guilty on counts 2 and 4. And as a result of that, they would dismiss Nolly counts 1, 3, 5, and 6.
All right. Is that accurate, Mr. Lewis?
It is, Your Honor.
Is that your understanding too, Mr. Chambers?
Yes, Your Honor.
All right. Sir, are you under the influence of any medications, alcohol, or drugs today?
No, ma'am.
Do you now, or have you ever suffered with or even been diagnosed with any type of mental health difficulties?
No, Your Honor.
Are you presently under any type of probation or community control supervision in this or any other state?
No, ma'am.
Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today?
No, ma'am.
Has anyone promised you anything at all if you enter into this plea of guilty today, other than the dismissal of the 4 counts that the prosecutor just outlined? Has anyone promised you anything else?
No, ma'am.
Are you making this plea of your own free will?
Yes, Your Honor.
Now, Mr. Chambers, the state has indicated that you would be entering a guilty plea to count 2 and 4 as charged in the indictment. Count 2 is aggravated vehicular homicide, a felony of the 1st degree, and count 4 is aggravated vehicular assault, felony of the 2nd degree. Is that your understanding of what's happening today?
Yes.
Is that what you talked with Mr. Lewis about before this hearing?
Yes.
Did you have an opportunity to review this 3-page plea form?
Yes, I did.
Do you understand what it says?
Yes.
Did you go over with your lawyer?
Yes.
Do you have any questions whatsoever about this 3-page plea form?
No, ma'am.
Now, I'm gonna go over some things in this plea form in just a moment, but, oh, there's no recommendation, right, on the, okay. I understand. All right, Mr. Chambers, do you believe you've had enough time to consult with your attorney about your entire case before this hearing today?
Yes, I have.
Has your lawyer answered all of your questions to your satisfaction?
Yes.
Have you reviewed the discovery and the evidence that the state has against you with Mr. Lewis?
Yes, I did.
Mr. Prosecutor, would you please put on the record whether or not the state has disclosed all discovery evidence, including any Brady material, if any, to your knowledge?
To the best of my knowledge, I have disclosed all such material.
Mr. Lewis, do you acknowledge what you're saying?
I do, Your Honor.
All right. Mr. Chambers, are you satisfied with your lawyer, Mr. Lewis?
Absolutely.
Now, sir, do you understand these two charges against you in count 2 and 4, aggravated vehicular homicide and aggravated vehicular assault?
Yes.
Do you understand that if you plead guilty to these offenses, you are making a complete admission that you committed the allegations contained in those 2 counts of the indictment?
Yes, Your Honor.
Do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
Yes, ma'am.
Now, I know that your attorney is going to ask the court for a pre-sentence investigation report, and I will likely follow that, but I will let you know that I could just proceed to sentence you immediately. Do you understand?
Yes, ma'am.
All right. Now, this being a felony of the first degree, let's see. And count 4 being a felony of the second degree. The first thing I want to notify you of is, do you understand that you are pleading guilty to an offense that carries an indefinite sentence?
Yes.
Do you understand? This means you will receive both a minimum and a maximum term.
Yes.
Do you understand that at sentencing, the court will select the minimum term for the range of penalties for your crime? Do you understand that?
Yes, ma'am.
So, for example, count 2 is a felony of the first degree, aggravated vehicular homicide. The court will select a term between the minimum of 3 years up to 11 years for that count. Do you understand?
Yes, Your Honor.
And then on count 4, aggravated vehicular assault, the court will select a term, because it's a felony of the second degree, between 2 years at the low end and 8 years at the high end. Do you understand?
Yes.
Do you understand that after the court picks the minimum sentence, the maximum term will automatically be the minimum, or the term the court selects, plus 50% of the minimum term? Do you understand?
Yes.
So, for example, on count 2, if the court were to select a term of 3 years, which is the lowest, then the maximum would be half of 3, which is 1.5, would be the maximum would be 4.5. Do you understand?
Yes.
The 3 that the court selects plus a half of 3 for the maximum of 4.5. Okay? Do you understand that?
Yes, ma'am.
But in turn, on count 2, because the range is from 3 to 11, if the court were to select 11, then the maximum would be half of 11, which is 5.5, for a maximum term of 16.5. Do you understand?
Yes, Your Honor.
So there's a wide range of penalties for count 2. With regard to count 4, aggravated vehicular assault, a felony of the second degree, the range is between 2 and 8 years. Do you know that?
Yes.
So if the court were to select the low end, 2 years, then the maximum would end up being plus 1, which is half of 2, for a total of maximum 3 years. Do you understand?
Yes.
And counsel, if at any time my math is off, please correct me. In turn, if the court were to select the highest term of a felony of the second degree, which is 8 years, then automatically there would be a 50% added on, which is 4, and the maximum term would be 12 years. Do you understand that?
Yes, Your Honor.
Do you understand that if you are pleading guilty to more than one offense, which in this case you are, that requires that the court impose an indefinite sentence? Do you understand?
Yes.
And do you understand that you will receive both a minimum term for each of those offenses as well as a maximum term?
Yes, ma'am.
All right. Do you understand that the court will also have to decide if those sentences on counts 2 and 4 are to be served concurrently, which is together, or consecutively, that's one after the other? Do you understand?
Yes.
And all of that will be determined at sentencing. Do you understand that?
Yes, ma'am.
Do you understand that if I sentence you to prison, upon your release from prison, you will be on post-release control? Did you talk to your lawyer about post-release control?
Yes, I have.
All right. So you will be on post-release control for the felony of the first degree for up to 5 years, but not less than 2 years. And on the felony of the second degree, 18 months up to 3 years. Do you understand?
Yes, ma'am.
And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand that?
Yes, I do.
All right. Are you on post-release control right now?
No. No.
All right. Do you understand that if you are on post-release control and you are convicted of a new felony offense while on post-release control, that in addition to being punished with a new offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains on your post-release control time, or whichever is greater. Do you understand?
Yes, ma'am.
All right. Now, I know I have given you a lot of information, and I've advised you of your rights with regard to a lot of information. Do you have any questions at this time?
No, Your Honor.
All right. If at any time you do have a question, just stop me, and I will be happy to answer your questions. Now, when you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to a trial, either to the court or to a jury of 12 persons?
Yes.
Do you understand you have a right to confront witnesses here in open court and have them cross-examined by your lawyer?
Yes.
Do you understand that you have a right to have witnesses subpoena to come to court and testify for you?
Yes.
Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt?
Yes.
Do you understand that at trial, you cannot be forced to testify against yourself?
Yes.
Do you understand each of these rights as I've explained them?
Yes, Your Honor.
Do you have any questions whatsoever about your constitutional rights?
No, ma'am.
Do you have any questions about anything we discussed this morning?
No, ma'am.
Do you understand that if you plead guilty, you are giving up or waiving all of these important constitutional rights?
Yes, Your Honor.
Knowing everything the court has discussed with you today, Mr. Chambers, do you still wish to enter a guilty plea to count 2 and count 4 as charged in the indictment?
Yes.
Counsel, is there anything further before I accept the pleas?
Nothing from defense, Your Honor.
All right, and here's statement facts.
Your Honor, the facts are regarding count 2 on or about February 2nd, 2021, Henry County, Ohio. The defendant was operating a motor vehicle and did cause the death of Paul Mizell, and as a approximate result of committing a violation of ORC 4511-19, which is OBI. He had a blood alcohol content of 0.148, and at the time of committing that offense, his driver's license was suspended under ORC 4511-10. He did not have a valid driver's license. At the time of the offense.
Did not,
Your Honor. And then on count 4, the same time, date, and location, the defendant of operating motor vehicle and did cause serious physical harm to Eliza, A-H-L-I-S-A, Carter, and as a proximate result of violation of ORC 451119, his OBI. And again, he was driving under a suspended driver's license under ORC 451110. Specifically on this, he was driving a vehicle, according to the black box data, he was going 77 miles per hour and 35 just seconds before the accident. Lost control of that vehicle, crossed the double yellow line, hit another vehicle head on. He did cause harm to the driver of that vehicle, Ms. Carter, and did kill the vaccine passenger, Mr. Lizell. You are also worth noting, including in the defendant's vehicle was another passenger. We had spoken to her, she did not wish to go forward on the charges, which is why her charge is being dismissed. But she is suffering injuries as well.
Passenger in his vehicle?
Yes, correct.
All right. Thank you. Mr. Chambers, did you hear what the prosecutor said you did?
Yes, I did.
Is it all true?
Yes.
What is your plea to count 2, aggravated vehicular homicide, a felony of the first degree?
Yes.
What is your plea to count 4, aggravated vehicular assault, felony of the second degree?
Yes.
Let the record reflect that Mr. Raymond Chambers was present in court with his attorney, Mr. Lewis, and that Mr. Chambers was informed of all of his constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Chambers understands the nature of the charges, the effect of the pleas, as well as the maximum penalties which can be imposed. Finding them to be voluntary, the court accepts the guilty pleas and finds Raymond Chambers guilty as to count 2, aggravated vehicular homicide, a felony of the first degree in violation of revised code 2903.06 subsection A1A. And finding his guilty plea to be voluntary as to count 4, aggravated vehicular assault, a felony of the second degree, the court accepts the guilty plea and finds Raymond Chambers guilty of aggravated vehicular assault, a felony of the second degree, in violation of revised code 2903.08 subsection A1A. Counts 1, 3, 5, and 6 are dismissed at the state's request. Is there any reason why sentence should not be entered today, Mr. Lewis?
Your Honor, may it please the court, we would ask the sentence not be imposed today. Respectfully requesting a pre-sentence investigation, Judge. I would ask that my client's bond be continued pending the sentencing date. The court can take note, I understand that my client understands it's a very, very serious charges. His legality, field, family, including his mother, his friends. Client has never missed any court appearance, Judge. They all, as ordered by the court, has picked up no new charges. Is gainfully employed as a nurse and would like to get his affairs in order. He's very well aware that his freedom will be taken away up to sentencing date. He was aware that prior to the plea, was aware that understanding had been convicted by a jury of his peers. And standing on his plea, he was aware that his freedom would be taken. He'd asked the court to not impose the sentence today, allow us to file a sentencing memorandum on his behalf.
All right, thank you. State.
Before we do that, Your Honor, I don't know if the court advised the defendant of a possible suspension of the driver's license as part of the plea required by the law. Because he did have the 81A conviction, he would be there would be a mandatory class 1 suspension, which would be a definite period for the life of the person. So you would just make a mandatory lifelong suspension of plea agreement.
Yes. And you know I can have that in the plea form.
Your Honor, it's not the plea, forgive me for speaking, Judge, may it please the court.
Yes.
It's not the plea form, my client was advised of that by counsel, he's aware of that, Judge, and would acknowledge on the record while it's not reflected in the Raymond Totes plea form, that he's well aware of the mandatory suspension.
All right. Mr. Chambers, are you aware, your attorney has made a representation and did talk to you about it, but I just need to confirm on the record, are you aware that this offense, pleading guilty to these offenses, will carry a mandatory lifetime driver suspension?
Yes, I'm aware.
All right.
Judge, we are good with a PSI victim impact statement, and we're good with letting them stay on the same.
Thank you, Mr. Chief.
All right, thank you very much. All right, I'm gonna order not only a pre-sentence investigation report, but I'm gonna order a victim impact statement, and I am going to continue this matter for sentencing. Ms. Howard, can we get a date? October 13th? Does that work for you, or do you need another day?
Sorry,
October 13th, please check.
Judge, the 13th works for me. I was just concerned that I would be in federal court today, but that date works.
Are you sure?
Well, we should be okay. I'm doing the day that afternoon. I think we'll be okay.
Okay. Is the 14th better?
14th is Friday, we do the 12th.
Oh, is the 12th or the 13th?
Either one's good with us.
13th is fine, Judge.
All right.
I mean, again, no day is fine for this young man because it's free, but 13th is fine.
All right, October 13th, 9 a.m. And Mr. Chambers, you will remain on the same bond. Now, you'll have to go over to probation so that they can do an interview of you for the probation investigation report, okay? And I'm gonna ask that you cooperate fully, answer all their questions, no matter how painful they are, answer all their questions truthfully. I will get a written report. I will allow the attorneys to see the written report before sentencing, and we'll proceed to sentencing on October 13th at 9 a.m., all right? Do you have any questions? All right, thank you very much. We'll see you then.
Thank you, guys. Appreciate it. Thank you, Judge.
Thank you, Judge.
Thank you, y'all.
Looks like, did I see Mr. Washington? I have a plea on you next, and I'm gonna do next, but I want to see Mr. Washington real quick.
Oh, yes, ma'am.
Where's the prosecutor?
Judge, I'll
Okay. This is on,
And don't listen to it.
yes. Yeah, let's do this on the record. Want to do it ready or do this on the record? Let's set it out.
Yes, sir.
Yes. All right. This is a matter of State of Ohio versus Randolph Wilson, case number B2102878A. Mr. Wilson is represented by Mr. Washington and Mr. Teeger for the State of Ohio. Now, Mr. Washington, your client is in the Justice Center. Do you want to brought over?
Judge, he's upstairs. I just left him 5 minutes ago, so he's aware of what's going on. We have actually been in negotiations all morning and this weekend, actually. We are remarkably close to not, although we don't have to resolve it, we are very close. So at this point, it's set the trial date, Judge. There is a DNA test result that we're waiting for. It's an item that we shipped out I think last month. So we both knew that it probably would be, we're still trying to negotiate a resolution. And I'm going to continue to do that. With regard to the trial date, I'm going to ask, I filed a formal motion to continue it Friday, just so the court will be aware. We've also executed a general time waiver in those cases, old Judge. We are, quite frankly, we're close enough that I would suggest my client accept this proposal, but he's not. But that being said, that's his right. So I'm going to ask for continuance and then have it set. I don't know if the court will set another trial date now, but I don't know what the timetable is to get the DNA back. Getting the DNA may be what's necessary to make this case go away. But I think that my client needs to see that final piece.
All right. Mr. Krieger?
Judge, I think everything Mr. Washington says is accurate. Maybe a trial date in November. I think would give us the time to get the DNA analysis done, and then maybe a trial in 30 days or so, and then that would maybe hopefully get the result and get us to where we
And again, I think the DNA result is going to be, I think will substantially impact my client's decision.
Now, from my recollection, the DNA is on some bags that was evidence that were confiscated.
It's from a bag that a large amount of fentanyl was found in. The state contends that was my client's bag. My client saying that he didn't have any contact with that bag. So DNA will resolve that for us.
DNA may resolve it, so.
Oh, it'll resolve that question.
It's either be yes, no, or inconclusive, and as we all know, if it's a no or inconclusive, it doesn't mean that he didn't touch it, but a yes certainly would mean that he did touch it, which I think would be important.
It certainly gives you something to talk about. Yes.
And is that really the holdup here for counts 1 through 9?
Are those the felonious assaults?
No, those are not the felonious assaults. This DNA is for the counts 1 through 9 of the drug-related offenses. All right. Then we have several felonious assaults. Yes. Still, I know you're trying to get a global plea, right?
Correct.
But are you on track for that to be?
I'd like to resolve everything at once. I think they all impact each other, Judge. And the number that we're coming up at is a global number. And just for the sake of it, we are 1 year apart.
One?
Uno.
Oh, right.
So basically, we are at 8, he said 6. I had, I think Ms. Oswald, Mr. Washington, and I said, how about 7? Mr. Washington, I think, would recommend it or went to reply with that. Apparently that was rejected by the defendant. So as he said, we are very, very close on something that he's facing a lot more time, potentially, if he's convicted.
Correct. A lot more time.
Okay, well, this case has been pending for 448 days. And your client has been in custody for 465 days. And I think everybody is aware of my feelings about cases pending while people are in the Justice Center. So I'm willing to continue it because you need the DNA results, but I'm not gonna continue it that long, particularly you guys are only 1 year apart. But it's Mr. Wilson's choice, so we have to, allow him to exercise his right. Ms. Howard, let's go ahead and continue the trial for the first available November. Because we're gonna pick a trial date and then there's no more continuances. Okay, because I don't want to get to November and say, we still need some more time to talk.
I think that's fair, Judge.
I agree with that.
But since it's Mr. Wilson's request to continue, I'm gonna go ahead and grant it and get the state in November.
And again, Judge, I believe the court, I think I presented a general time waiver for these back.
You did, thank you.
Number 7.
I started trial, it was a 2-week trial in Butler County on a 37-count day on the 1st.
Okay.
Can
you do 14?
I started trial with Judge Shanahan.
now he's out, that's lowercase two, but he's out. I like to think if I said this for the 14th, that I could go to Judge Shanahan and say, I've got a guy that's been incarcerated for 500 days. And hopefully the court will understand it. So, yes, let's do the 14th.
Okay.
At least I can try to get one of these two done.
Okay, so let's set it for the 14th at 10 a.m. And we had a final pre-trial conference on this already, so I really don't want to set another one of those, but I can go ahead and put a status in between just to make sure that the DNA has been, all right, and then if you resolve it, we can always resolve it that day. How about sometime in October, Ms. Howard, a month from now or a little longer for status?
We can do, October 5th.
October 6th?
5th.
What about 30 days?
30 days is gonna take us into the 12th, and set the trial.
Oh, yeah, the trial on the 12th.
We want to do the
Is the trial on the 12th in another county?
No, that was November. October 12th is a fine day for me.
Okay, October 12th? Can we do October 12th, is that?
Yes.
All right, October 12th for status, 9 a.m. Time is made.
Yes, ma'am.
All right, thank you very much.
Thank you, Judge.
Just, as soon as it comes out, I'm just.
All right, I think we have a few minutes. There's any dates? Okay, who needs, who wants any dates?
Poindexter? It's a key district call. Look at Poindexter.
Okay, yes. State of Ohio versus Board of Poindexter, case number B2005883. Mr. Tim McKenna for Mr. Poindexter, Mr. Keepner for the state of Ohio. Mr. McKenna, you're on this case now, how do you want to proceed?
Good morning, Judge. Nice to see you. We planned last year, I believe it was March or April, and Mr. Poindexter habeas 3 or 4 times for sentencing. It's about a year later now, and he's subsequently been picked up and arrested on a new charge. It would be my goal to get them together on the same date so we can work out together. I don't know when the new dates will be. I would just suggest continuing this with the intention of eventually matching the dates up, Your Honor. I'd suggest October 5th.
Okay, let's see, the new date looks like it's, he has arraignment this Friday. So Ms. Howard, how long will that be? 2 weeks after. So let's set this for a date, and then, that will catch up. So we'll set this for a clear trial 7. Time, presence date?
Yes, sir.
Mr. McKenna, did you say October 5th?
Yes, sir, just October 5th.
All right, October 5th, 9 a.m. Time,
Yes, ma'am, thank you.
thank you.
We will set it as a Saturday.
Clear trial 7. All right, I really need to get this to you next, but I've been very patient. All right, this is the matter of State of Ohio versus Michael Eubanks, case number B22001613. Mr. Eubanks is present in the courtroom with his attorney, Mr. Tiedemann, and Ms. Jennifer Deering from the state of Ohio. All right. This matter is set for a jury trial today, but I've been handed plea forms, and is this how your client wishes to proceed today, Mr. Tiedemann?
Yes, ma'am.
All right. Is this accurate, Mr. Eubanks, you want to plead guilty?
Yes, Your Honor.
All right, thank you very much. Are you the Michael Eubanks named in this indictment?
Yes, Your Honor.
Sir, how old are you?
I'm 28 years old.
How far did you go to school?
I graduated from Troy High School. I'm
currently in college right now, pursuing my major in entrepreneurship.
All right, thank you very much. So you're able to read and write the English language well?
Yes, Your Honor.
Sir, have you ever served in the military?
No.
Are you a U.S. citizen? I've been handed a document, entitled Waiver of Trial by Jury. It's a single-page document. There are signatures at the bottom. I recognize your attorney's signature here, Mr. Teepin. Is this your signature here, sir, where it says defendant?
Yes, Your Honor.
Sir, this is an acknowledgement by you that you understand that you have a constitutional right to have a trial, which was set for today. But when you sign this form, you're saying, I understand that, but I'm waiving or giving up my right to a trial. Is that your understanding of what you were doing when you signed this form?
Yes, Your Honor.
Did you sign this form after consulting with Mr. Teepin about your constitutional right to a trial?
Yes, Your Honor.
Do you have any questions about this form?
No, Your Honor.
Do you have any questions about your constitutional right to a trial? Mr. Eubanks, I also have in my hand a 3-page document entitled Entry Withdrawing Plea of Not Guilty and Entering a Plea of Guilty. On the 3rd page, there are signatures. I recognize the prosecutor's signature here, Ms. Fearing, your attorney's signature just above, but up here, sir, where it says signature of defendant, is that your signature?
Yes, Your Honor.
All right. Madam Prosecutor, would you please put on the record the party's expectation regarding this plea?
Your Honor, the state is going to amend count 2 from Williams assault, count 2 aggravated assault. I have spoken with the victim in the past, the victim's mother, I'm sorry, well, she's also the named victim, Ms. Alyssa Harris, and she indicated to me that she thinks that this incident was a result of the defendant being under with alcohol. She says that she thinks that's her concern with this individual. She says he's not a bad person or anything, she just is concerned about his alcohol use. So we are asking that you set this over and perhaps have the defendant discuss to see if treatment is warranted in this case.
I see. Now, does the victim and defendant know each other?
Yes, they have a child, one child in common, right? One child in common.
Oh, okay.
The child, just for what it's worth, this is an incident in which the defendant drove his vehicle into a vehicle that contained 4 children, 2 adults, one of the children was his children. Luckily, though, when my child was injured and minor injuries to his leg was cut, he was treated on the scene by the fire department, did not get good at the hospital or anything like that. But so that's the one count that I'm having lead to compensate for the child that did actually receive injuries and medical attention.
All right, and so this is all with the permission and consent of the alleged victim and family?
I haven't talked to the victim and feeling, but when I did, this is the resolution that she indicated to me was her concern.
All right.
And I talked to the officers that are here, and they're in agreement that this is the best way and most appropriate way to go forward.
Okay.
And just for what it's worth, I have another witness that I left on call, because he's in school and I didn't unnecessarily look at.
Understood. All right. Mr. Teepin, is this accurate with regard to the plea to just count 2 being reduced and amended from felonious assault felony the 2nd degree to a aggravated assault felony the 4th degree?
Yes, Your Honor.
All right. Is that your understanding too, Mr. Eubanks?
Yes, Your Honor.
All right. Sir, are you under the influence of any medications, alcohol, or drugs today?
No, Your Honor.
Have you ever been diagnosed with any type of mental health difficulties?
No, Your Honor.
Are you presently under any type of probation or community control supervision in this or any other state?
No, Your Honor.
Has anyone threatened, forced, or coerced you in any manner into entering into this plea of guilty today?
No, Your Honor.
Has anyone promised you anything at all if you enter into this plea of guilty today, other than the dismissal of counts 1, 3, 4, 5, and 6?
No, Your Honor.
Are you making this plea of your own free will?
Yes.
Now, the state has indicated that you would be entering a guilty plea, or it's expected that you would enter a guilty plea to a reduced charge in count Well, it's not only reduced, it's amended. In count 2, from felonious assault, a felony of the 2nd degree, to an aggravated assault, a felony of the 4th degree. Do you understand? Is that what you talked with Mr. Teepin about before this hearing today? Did you have an opportunity to review this 3-page plea form with your lawyer before this hearing today? Do you understand what it says? You have any questions about it? Mr. Eubanks, do you believe you've had enough time to fully consult with Mr. Teepin about your entire case before this hearing today?
Yes, Your Honor.
Has your lawyer answered all of your questions to your satisfaction?
Yes.
Have you had an opportunity to review the evidence that the state has against you with your lawyer, Mr. Teepin?
Yes, Your Honor.
Madam Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material, if any, to your knowledge?
I believe I've provided it several times, kept not going through properly, but I think if I got that correct.
Correct, Your Honor.
All right. Mr. Eubanks, are you satisfied with your attorney, Mr. Teepin?
Yes.
Now, sir, do you understand the charge against you in count 2 as amended to aggravated assault and reduced to a felony of the 4th degree?
Yes, Your Honor.
Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in that count of the indictment?
Yes, Your Honor.
And do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
Yes, Your Honor.
Now, this being a felony of the 4th degree, do you understand that you are facing up to 18 months in prison
Yes, Your Honor.
and up to a maximum fine of $5,000?
Yes.
Do you understand that if I sentence you to prison, upon your release from prison, you could be on post-release control for up to 2 years?
Yes, Your Honor.
And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand that? Are you on post-release control right now?
No, no.
Well, if you are on post-release control, do you understand that if you are convicted of a new felony offense while on post-release control, that in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains in your post-release control time, or whichever is greater. Do you understand?
Yes.
Any questions?
No, no.
Also, since this is a felony of the 4th degree, community control is a possibility, probation. Do you understand that I could place you on community control or probation for up to 5 years instead of sending you to prison?
Yes, Your Honor.
Do you understand that if you are placed on a community control sentence, you will have to abide by all probationary conditions as established by this court?
Yes, Your Honor.
And if I place you on community control and you violate the conditions of community control, you'll be brought back before me for a more restrictive sanction, which could include a whole host of things. But the most severe sanction could be prison time up to the 18 months that I previously discussed with you. You understand?
Yes, ma'am.
Also, if I impose court costs and you fail to pay those court costs, I could order you to do community service instead of paying court costs. You understand?
Yes, Your Honor.
Do you have any questions at this time?
No, Your Honor.
Mr. Eubanks, when you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, which is scheduled for today, either to the court or to a jury of 12 persons?
Yes, Your Honor.
Do you understand that you have a right to confront witnesses here in open court and have them cross-examined by your lawyer?
Yes, Your Honor.
Do you understand that you have a right to have witnesses subpoenaed to come to court and testify for you?
Yes, Your Honor.
Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt?
Yes, ma'am.
And finally, do you understand that at trial, you cannot be forced to testify against yourself?
Yes, Your Honor.
Do you understand each of these rights as I explained them?
Yes, ma'am.
Do you have any questions about your constitutional rights?
No, Your Honor.
Do you have any questions about anything we discussed?
No, ma'am.
Knowing everything the court has discussed with you, sir, do you understand that, well, I want to ask knowing everything that I've discussed with you, do you still wish to enter a guilty plea to the amended and reduced charge in count 2 to aggravated assault, a felony in the 4th degree?
Yes, Your Honor.
All right. Is there anything further before counsel before I accept the plea?
No, Your Honor.
All right, I do want to talk to you real quick, remind you, it was in your plea form that your driver's license could be suspended, I believe, on this offense. Can't you read it?
Aggravated assault, I don't.
I'm not 100% sure, to be honest with you.
Okay.
I have to look up the specific charge.
All right.
It wasn't charged as an aggravated particular assault, the original charge was a felonious assault.
Okay.
So, and the deadly weapon happened in a motor vehicle, but I think that's different than if this were aggravated particular assault stemming from an OBI.
Yes. So in the plea form, though, I just want to go over it with you. It may not apply, all right? But you have indicated in your plea form, I understand that by pleading guilty, the trial judge may, in addition to or independent of all other penalties provided by law or by ordinance, suspend or revoke my driver's license or commercial driver's license or permit or non-resident operating privilege for a period of not less than 6 months or more than 5 years. Do you understand that? I just want to make sure that you saw that.
Yes.
Now, it might not apply, it might not happen, but it could, so I'm going to advise you. All right? All right, may I hear a statement of facts?
Yes, Your Honor, this charge, count 2 indicates that on or about April 2nd, of the year 2022 in Hamilton County, Ohio, the defendant knowingly caused or attempted to cause physical harm to J.W. by means of a deadly weapon or dangerous ordinance to wit an automobile. As charged as a violation of section 2903.11A2 of the Ohio Revised Code. However, as indicated to you, Your Honor, the state is amending this to reflect that he is entering a plea to aggravated assault, a felony of the 4th degree. By way of additional information, Judge, this offense took place when the victim and another adult, well, since they're all victims because they're all named in the indictment, but when 4 children and 2 adults were parked at a gas station in order to fix a flat tire. The defendant did see them and drove his motor vehicle into that motor vehicle, causing injury to the 1 minor child, JW. The vehicle didn't let him see, and he was apprehended very shortly thereafter by police.
All right. Thank you. Mr. Eubanks, did you hear what the prosecutor said you did?
Yes, Your Honor.
Is it true?
Yes, Your Honor.
What is your plea to count 2 as amended and reduced to an aggravated assault, felony of the 4th degree? What's your plea?
I'm guilty.
Let the record reflect that Mr. Michael Eubanks is present in court with his attorney, Mr. Craig Tevin, and that Mr. Eubanks is informed of all of his constitutional rights, has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Mr. Michael Eubanks understands the nature of the charge, the effect of the plea, as well as the maximum penalty which can be imposed, penalties which can be imposed. Finding it to be voluntary, the court accepts the guilty plea and finds Michael Eubanks guilty as to count 2 as amended and reduced to aggravated assault, a felony of the 4th degree, in violation of revised code 2903.12. Counts 1, 3, 4, 5, and 6 are dismissed at the state's request. Is there any reason why sentence should not be entered today?
Judge, my understanding is the prosecution would request a pre-sentence investigation, and we certainly have no objection to that.
All right. I'm gonna order a PSI and victim impact statement, as well as an inability of treatment. I think that's what was requested, correct? Yes. Advisability. Advisability, inability, same thing. Yes.
Same thing.
Yes, all right. All right, let's go ahead and get a sentencing date.
Your Honor, please ask if possible, can you stay away from Monday?
Okay.
Other than that.
Yeah, I usually would put on Monday, the only flash files like that, usually. Yeah. I try not to. October 13th, 9 a.m. Does that work? All right, excellent. So you'll be coming back October 13th, 9 a.m., Mr. Eubanks. And right after court, you need to go to the probation department, so you'll have a pre-sentence investigation interview. It should be short. And then I'm gonna ask you to cooperate fully, answer all questions truthfully, and then I'll get a report, a written report. I'll let the attorney see it before the sentencing, and then we'll proceed on October 13th at 9 a.m. All right, any questions?
Your Honor, would you consider removing EMD from now until sentencing? He's been on it since this case began with no violations. He's made every court date. He is working and just started up school, so you were gracious enough to give him some hours out for previous court date, but he would request the removal now that there's been a substantial reduction in the charges.
Well, and the other thing is, let me ask, is that something that you can talk to the,
Last time I talked to, I can certainly, but I will tell you this, last time I talked to the victims, not regularly, but as a spokesperson, there are currently in place, domestic violence TPOs as a relationship to all of that, and she said that that was a very important factor to her, that we stay away. So I feel comfortable representing that as long as those remain in place, that's the biggest concern.
all right, thank you.
When I did talk with the other victim, when we wanted to do the bond hearing, she was in favor of the defendant doing what was necessary in order for him to have employment and a job. She was very encouraging in that. Just once again, I'm concerned about stay away.
All right. All right, so the oral motion to terminate the EMD is granted, but I am advising you out of my mouth, it's order of the court to stay away from any victims in this case. Do you understand?
Yes, Your
All right. I'll see you on October 13th.
Honor. Thank you, Judge.
There's a injury granted with the oral motion.
Thank you, gentlemen.
All right, Ms. Oliver, you've been here a long time.
Yeah, I believe Mr. Harper is on his way down.
Oh, great.
Mr. Eckler, how?
All right, Mr. Howell, yeah, Mr. Neff.
Judge, good morning.
Good morning.
We're here for a status now.
All right. Yes, Mr. Howell is the justice, do you want to run down?
He's upstairs. Judge, I'll leave it up to you. I'm comfortable with these hearings.
Well, you're comfortable with his presence, that's fine.
We had a previous status, and you requested this one. The court is concerned, so I can tell you, I met with him, are we ready? I met with him just a week or 10 days ago, and we're on track to resolve the case. I did confirm with him, he received everything that I've sent to him. I resent some additional documents to him. I believe we will resolve this case short of a trial. We don't wait these trial at this point.
All right, so this is case number B210546, Annabelle Howes, Donnie Howell, Mr. Kerry Neff for Mr. Howell, Ms. Kristen Keepner for the state of Ohio. Ms. Keepner, what do you want to say?
Judge, we have nothing to add. We do have future dates. I have, we have had the discussions as recently as this morning. I too think it will resolve itself, but there's nothing to add.
All right, well, the parties are in the negotiations, and we have a final pretrial conference date set October 13th. You just want me to leave it on for that date?
Yes, yes, sir.
All right, well, we'll keep it on that date as scheduled, and the jury trial as scheduled for November 7th. And we will move on.
Okay. Judge, only thing I can just have with the last report is Mr. Howell did request that I file a motion to reduce his bond. I have that done for two reasons. One, we're so close to resolving the case. So the second, there's a order on him. He's on supervised release, federal court.
I see.
So I'm assuming the court would not grant his bond reduction because you would discuss it temporarily.
If there is a active holder in place, that is correct, I would not, because what would happen is I would lose jurisdiction over him.
Right.
And if you need him to come to court for me to say that, I can do that, because I want him to be aware, but if you all have a great relationship, right now, then, and he would receive that information well from you, then I'll just let you do it with the message.
I think he will, and I'll do this if there is an issue and he doesn't, trust what I'm telling you, I'll say it.
All right.
Let me go.
All right, so yes, we'll continue as already scheduled, and, I don't know if you know already, but I did receive this wonderful letter.
I did too.
The letter that where he apologized for his actions the last time he was in court, let him know that I did receive it, I did read it, and I did very much appreciate it.
Okay, I'll make sure it is.
All right, thank you very much. I'm gonna do this,
I'm going to be first year or Harvard, whichever one you prefer.
Okay.
I don't know if you're. Are they about that? Mine is, I don't
This
know.
is how you call her now?
Yes.
Okay, so Wickham Harbor, and then we'll do Mr. Greenberg, he has it, Mr. Greenberg, did you get the ILC information?
Yes, I did, thank you.
Okay.
She does appear to be on the floor. She would like to avail herself of the opportunity to do it.
Okay. All right, we're gonna do Harvard first, and we'll do, Thursday. You have all the reports, you, Ms. Culver?
Yeah, I did, I see them here.
Okay.
Is your back? No, that's not covered. Not the room. St. Jerome. It was a whole St. Jerome. It's a sweet person.
Ms. Culver, you wanna go ahead and have just a conversation about Mr. Harper before he gets down?
Absolutely.
What is the breaker? Yeah, you
Just
say
things.
you don't have to worry about that.
I don't think you want me to marry you anyway, so.
Oh, you've been sick.
I got a cold.
You got a cold, yeah.
I tested.
Even when you had allergies and you start sniffling, everybody's like,
I know. You're like a pariah in this place.
all right. So, I did everything I knew to do to help Mr. Harper. I recall on that day being off of the bench and making calls myself to get him into this program. Because you made such a compelling argument for him. Despite the state's and probation's I think recommendation to do otherwise. But yet I still went out of my way, and then he just walked away.
Your Honor, so he was at Turtle Creek, are you on the record? Or
No.
Okay. He was at the Turtle Creek program. He texted me and called me several times while he was there. And the court knows that he has a sex offender conviction from back when he was, I want to say 18 or 19. Where he rented the club, where you had to show your ID to get into this club. You went home with someone, turns out she was less than 18. The problem is, for Mr. Harper, just more broadly speaking, is that conviction and all of the consequences that go with that have just absolutely exacerbated all of the issues he had before. His mother is here, I do want to note that first. I've known her and Ray since 2006, actually. So I was with JPC when Ray came through on the sex offender registration status hearing. When he got to Turtle Creek, they wanted him to do sex offender treatment. And that's why he was texting and calling me saying, I don't need it, I don't want to do it. You know, and frankly, Your Honor, and certainly with all due respect, he's not what we typically think of when we think of a sex offender. He does not fit that mold. He doesn't fit all of those things that come with it. And it's just exacerbated our argument for him. He needs mental health treatment. He needs substance abuse treatment. There is no dispute about that. I think the issue that we've run into with Mr. Harper, and I'm referring to the court as well here, when we say we, is that Talbot Health, River City, there are very few places that will take him because of that sex offender status. I am still hopeful, and I know that I am asking so much of this court, for him to do city gospel mission. And if
For him to do what?
City gospel mission. Sorry,
Your original.
My original request. What I can share with the board is that he did turn himself in on this producer violation. Knowing full well he was going to get locked up. While during the time between he left Turtle Creek and the time that he turned himself in, he did reach out to City Gospel Mission. They said that they would take him, that he was a good candidate for the program, and that they would not take him while he has an open warrant. And I think that was part of the emphasis in him turning himself in to address this charge.
The thing is, and I know that was your first initial request, but the court has no relationship with this program, right? And Mr. Doctor is here, so let's go ahead and call this case.
Your Honor, can you get it to me or to the court?
Well, he can stay in the box because
Sorry.
that'll be fine, unless he wants to stand.
Up to you.
You okay? All right. All right. This is State of Ohio versus Rutledge Harper, case number B 20049. I'm sorry, 5917. Mr. Harper is present in the courtroom with his attorney, Ms. Colliver, Ms. Keepner for the state of Ohio. This is a probation violation, and this matter was continued, I believe, from a couple of weeks ago. But Mr. Harper refused to come to court.
Your Honor, I actually went to see Mr. Harper after court that day to find out what was going on. I was really surprised that he refused to come to court, and he was actually stunned to hear it as I was. He said that his pod was in COVID lockdown, and that he was not even given the opportunity to come over. I have never known Ray to refuse to come to court or do anything of the sort. So he absolutely did not refuse to come over. I do want to be clear about that.
All right, well, that was the information given to us by the jail. We call over every morning, and that's what they told us, so. But anyway, he's here today, and we have a violation. Do you want a probable cause hearing?
We would waive a probable cause, Your Honor.
What's the plea?
Guilty.
All right, we hear statement of facts.
Madam Judge, the defendant is alleged to have violated Rule 11 on May 29th of 2022. The probation department was notified that Mr. Harper, had left the Turtle Creek Center facility without permission and had not returned as a result of the filing of the warrant.
All right, Mr. Harper, did you hear what the prosecutor said you did?
Yes.
Is it true?
Yes.
All right, what's your plea to the violation of community control?
Guilty.
There's a plea and finding of guilt on the probation violation. All right, Ms. Colliver, now we can continue our discussion now on the record. What do you want to say on behalf of Mr. Harper?
Your Honor, I'm certainly not going to repeat everything that I've shared with the court multiple times. The long and short of it for Mr. Harper is that he needs treatment and he wants treatment. There's no two ways around that. He needs both mental health treatment and he needs substance abuse treatment. What he does not need, and I'm very comfortable representing this to the court, on behalf of Mr. Harper, is he does not need sex offender treatment. I think that exacerbates all of the other issues he has. We've already talked about the fact that Mr. Harper is not eligible for either the Toddler House or the River City program, given his criminal history or his criminal background on that matter, which is very limiting for this court and it's very limiting for Mr. Harper. I have looked into, and I know that the court is so reticent and concerned, and I understand it about the city master mission. I completely understand the court's reservations. What I want to share with the court is that I have had several clients do this program.
The Naked Exodus program?
Yes, with great success. I have, and it's not success over a period of 6 months, success over a period of years. Mr. Harper, I was telling the court this before we walked into the room, that Mr. Harper did reach out to them to see about that being available, about getting into the program. They would not take him with an open warrant, hence he turned himself in to address this. My suggestion, and I know it's a big ask, is to make that a condition of probation. Probation can monitor his compliance in the program and making sure that he's there. He can be on electronic monitoring while he is there, to ensure that that is where he is staying. Certainly, we decided for status reports over a period of time, to come back to this court and have him cross the court, or even in the absence of him coming to court, the court getting reports and myself as his representative legally coming to court, to make sure that he's doing what he's supposed to and getting the treatment that he needs and that he wants. I understand at this point, probably the court has reservations and thinks Hague Prison is probably the best option and my only option at this point. I'm really asking this to give them another chance. You know, even, I shared with the court that I've known him since 2006. Even when he hasn't been in trouble, he stops into the office sometimes just to say hi, to share how he's doing. I think he has so much potential, and I'm just hopeful that he can get this through the city council commission. And I will speak on that unless the court has questions about that.
All right, thank you very much. Steve.
Judge, I just have concerns about going through that program is when I'm looking at these notes, it looks like EMU had asked you previously to revoke his bond because they did a home visit, he was refusing to open the door. And then he left this Turtle Creek Center facility, which you gave him a gift to go there, and he decided he didn't want to do that either. So I just have concerns that he's not going to want to follow through with this program either.
All right, thank you very much. Mr. Harper, what do you want to say before I decide what we're doing?
I ended up leaving Turtle Creek because they wanted me to take sex offender program, and I dealt with that like 18 years ago, so I didn't understand the whole concept that we keep repeating doing the same thing over again. So that was
Well, what did I tell you to do, Mr.
the 90-day drug treatment program. They told me I had to take that class.
Okay,
Yeah,
okay. You know how long the program was?
9 months.
9 months.
Yeah, with the
With the aftercare.
with the aftercare.
No. Okay, yeah, 9 months. But how long was the program that you had to be at Turtle Creek?
So
90 days. And so when did you leave in the program? When did you walk away?
In the May.
How long have you been there before you left? Couple days?
A week.
A week. A week. Because something you didn't want to do. You can continue, go ahead.
It was gonna put me in a crazy mindset I wasn't trying to get into, and so I had to leave.
So you had to leave.
Yeah, there's no.
And when you left, did you think that the court was gonna be happy about that?
No.
So now, what are you asking me to do? Now you have your lawyer asking me to do something else. But I made my decision. But you don't want to do that. Right?
I have no problem doing that. It's just the other class I didn't want to do.
Well, Mr. Harper, I understand the reasons behind why you may not have wanted to do it, but it's an order of the court. You're in court, look around. You're in the Justice Center. And when you don't do what they tell you to do at the Justice Center, what happens? There's penalties and sanctions, right? Same way in life. Sometimes we have to do the little piece that we don't want to do to get to what we want. And what you wanted was some mental health and drug treatment, right? And you wanted to be somewhere for a short period of time. Because I could have just sent you to prison. Right? That was an option. Remember we talked about that? That was an option. I could just send you to prison. Now I know if I send you to prison, that's definitely not what you want to do. Right? All right. So I gave you an option of 90 days, 3 months. And yeah, you might have had to take a class that you didn't really necessarily want to take. a class. And you didn't want to do that, so you just walked away. And now you're coming to me saying, well, I want you to do this. I'll do it if you do this. But see, this is not, we don't bargain here. Do you understand? The problem with the request is not the request in and of itself. Because I've got some information about the Exodus program, I'm looking at it online, it looks like a great program. It's not the request, it's whether or not you will do what you're supposed to do. Because every time you've come before me, Mr. Harper, you said, I'm gonna do that. Yes, I'm gonna do that. And you've not done anything. That's the issue I have today. Do you understand? I'm not real confident that anything you say you're going to do, you're going to do it. That's where we are. So, how do I get comfortable that you're going to do something you say you're going to do when you haven't done it the other 3 times? How? Tell me, and I will listen.
Well, I know one thing that my whole mindset is better than it was before I was talking to you. I'm not in that whole depressed, crazy mind or whatever you said. I feel it's better.
And you feel better because what? What has happened to make you feel better?
I got to talk to my babies and everything and situate that whole issue.
Do you have any, were you prescribing medication?
Yeah.
Since the last time I saw you?
Yes.
Have you been taking the medication?
Yeah, I had different ones I was taking.
Are you still on medication?
No, never.
Who stopped you?
I haven't since I've been in jail.
Did you get a spray?
Yeah, they did.
Since you've been in the Justice Center? Okay, but when you were at Turtle Creek, were you getting it?
No.
When's the last time you had any medication? Is that part of the issue that he needs to be prescribed medication? Is there a diagnosis that he needs medication for?
I don't know that there's a specific diagnosis. Your Honor, if it's okay before I'd like to call his mother out, maybe it's.
Good morning, Ms. Harper.
Yes, thank you for allowing me to speak. All that you were doing represents what you see in front of you, but there's much more to him. He lost, my husband died when he was 4 years old, doing that. So I basically was a single parent. He got involved in a lot of community, being participating in the community, doing voter type things and civic engagement.
And I'm sure that's due to your involvement with the NAACP.
Yes. He started experimenting with drugs before I knew he was experimenting with drugs. Before that time, he's always been very hyper and attention deficit, which, but it didn't affect his character. Very kind, very caring, very generous, going to do anything for anyone and give anyone anything he has. But he does have a problem with controlling impulses, and most of it, I believe, had to do with experimenting with drugs and what it does to his control and getting in risky situations. I know that since when he was starting to get in trouble, he was about 18, and that one offense caused him to feel hopeless about his whole life because it defines him in a way that is very ugly and awful. And when he took that class, it took so much out of him, because of the things they made you think about. And he's in a class with people that are in a different category than him, but you're lumped together. So it emotionally took a toll on him. And he's made some bad choices because of having a record. And because when you have a record, it does put obstacles and additional challenges in your path. But he couldn't see that it's possible to reinvent yourself because of the hopeless state. But he does have ADHD, and anxiety, and extreme depression, but it could also be bipolar, because I've seen extremes in his personality. From 1 second and 2 seconds later, he's someplace else.
I see.
Emotionally. So, and it has been not treated. When he was younger, I didn't have access to health care, so I couldn't treat some of the impulsive things that was going on. Later on, when he became an adult, you don't have a say in what's going on in that person's life.
Yes.
So I couldn't advocate for that. But if the court could give him services such as treatment for controlling his impulses, for anxiety and depression, it would help him a lot, as well as drug treatment, so he doesn't self-medicate. Because I believe a lot of the drugs that he started using had to do with the sexual predator case, and he wanted to just medicate himself.
I see.
So
So his attorney has asked, and he's asking me that he participate in this Exodus program. It's a men's program through the City Gospel Mission. Looks like a great program, but it costs money. So, I mean,
he does have insurance, and I believe the insurance may take that care of insurance.
Okay. All right, thank you, Ms. Harper.
Thank you.
All right. Mr. Harper, we're at the end of the road here. You understand that? What I'm gonna do is I'm gonna add 1 year to your community control. So, I don't know, we might get 3-4 years now. Adding a year of community control, it's gonna be intensive supervision. I'm gonna make a condition of your probation that you successfully complete the Exodus program. If you do not, just like I said, we're at the end of the road. If you do not complete the Exodus program, I will send you to prison. Don't ask me to send you to another program or do anything else. Do you understand? All right, so now it's on you. Now, I don't know what the City Gospel Mission is going to, classes, the type of classes. I can see that, the type of help they offer, the treatment, the mental health, the drug treatment, and much more, actually. They look like they're very expensive. But they may ask you to do a class that you may not want to take. If you walk away, you're going to prison. All right? All right. I'm going to cost your net. Now, Ms. Colliver, do you know if there's a bed awaiting or no? Or this has to happen after he's really resolved the case?
Yeah, sure.
All right. Well, we'll tell probation. So I'm going to go ahead and allow you to be released and get to that program. And you're going to be on intensive supervision. You understand? Now, This is probation with the condition that you enter and complete the program. So if you don't enter the program, that's a violation. Do you understand? If you don't enter the Exodus program, it's a violation. And what happens on a violation?
I'm going to prison.
Yes, all right. Anything else?
Just thank you very much for giving me the opportunity, Your Honor.
All right. Anything from the state? Okay. All right, your right to appeal your conviction or sentence, should you choose to do so, you must do so within 30 days. If you cannot afford to process the appeal, an attorney will be appointed to help you at no cost to you. Do you understand? I wish you well. Ms. Thurston? Did you have a big time to catch up?
No, I was supposed to, I had 2 different orders last week, and of course, neither of them went, but I had to.
Yeah.
So I did get something.
Did you still have to record? Yeah. Cool. This is well. All right, this is the matter of State of Ohio versus Audrey Thurston, case number B22011107. Ms. Thurston is present in the courtroom with her attorney, Mr. Matthew Greenberg, Ms. Kristen Keefer from the state of Ohio. This matter is set for a motion for treatment in lieu of conviction. And let's see. I do have a report. The court ordered a court clinic evaluation for purposes of ILC evaluation. I received a report dated September 9th, 2022. It is 7 pages. The assessment was done by Rachel Dubose, forensic assessment clinician. And based on the questions asked, Ms. Dubose gives the opinion that Ms. Thurston meets the clinical criteria for intervention in lieu of conviction on the offense charged, which is aggravated possession of drugs of felony with the 5th degree. Mr. Greenberg, have you received a copy of this clinic evaluation?
Yes, I have. I've reviewed the report by Ms. DeRose, and the defense stipulates to the
State.
If you get the opportunity to read it.
Stipulate to the report? Yes. All right. So Ms. Audrey Thurston is charged with an eligible criminal offense as defined by Revised Code 2951.041B. Considering the conditions set forth in that code section in subsections 1 through 9, I find that the conditions are met and will grant the motion for intervention in lieu of conviction. Any objection by the state? All right. Are you the Audrey Thurston named in this indictment, ma'am?
Yes, I am.
How old are you?
54.
All right. How far do you go to school, ma'am?
Some college.
So you're able to read and write the English language well?
Yes and no.
All right, tell me about the no part.
I had a stroke.
Recently,
Yes.
which is why you're in a wheelchair?
Yes, ma'am.
All right, because I know on previous occasions you walked in here and, she's always been in a wheelchair?
As far as I know, the report,
I had a stroke in November of 2020.
2020. Okay, I apologize. I thought one day you were in here, you were not in a wheelchair.
No.
All right. All right. Have you been able to communicate effectively with your attorney to the
Yes.
extent that you're able to understand what he was saying?
Yes.
All right. And do you understand what you're doing here today?
Yes, ma'am.
All right. Do you understand that my granting you the opportunity to participate in an intervention plan involves you also entering a guilty plea to the charged offense?
Yes, ma'am.
All right. Ma'am, have you ever served in the military?
Yes, ma'am, I have.
All right, can you tell me about that?
I served in the Army. I got hurt in basic, but I graduated.
All right.
So I was considered a soldier.
Thank you.
And I served in 2 really good reserve units.
All right. So are you a US citizen?
Yes, ma'am, I am.
All right. Mr. Greenberg, would you please put on the record whether or not you believe your client is well-informed and able to go forward with the plea? I know she has some maybe difficulties or delays in communication, but does she fully understand in your opinion?
in my opinion, she does.
All right, thank you. Ma'am, I have in my hand a single-page document entitled Waiver of Trial by Jury.
Yes, ma'am.
At the bottom, there are signatures. I recognize your attorney's signature here. Is this your signature right above where it says defendant, ma'am?
Yes, ma'am.
All right. Ms. Thurston, this is an acknowledgement by you that you understand that you have a constitutional right to have a trial. But when you sign this form, you're indicating, I understand that, but I'm giving it up. I'm waiving my right to a trial. Is that your understanding of what you were doing when you signed this form?
Yes, ma'am.
Did you sign this form after you consulted with Mr. Greenberg about your right to a trial?
Yes, ma'am.
Do you have any questions about this form?
No, ma'am.
Do you have any questions about your constitutional right to a trial?
No, ma'am.
I also have in my hand a 3-page document entitled Entry Withdrawing Plea of Not Guilty and Entering Plea of Guilty. On the 3rd page, there are signatures. I recognize the prosecutor's signature here in blue. Right above is Mr. Greenberg's signature. And then above that, where it says signature of defendant. Is this your signature, ma'am?
Yes, ma'am.
All right. Madam Prosecutor, would you please put on the record the party's expectation regarding the plea?
Judge, it's our understanding that she will be pleading the charge for this offense, and they will be asking her to be accepted into the treatment and conviction program.
All right. Is that accurate, Mr. Greenberg?
Yes, sir.
Is that your understanding too, Ms. Thurston?
Yes, ma'am.
All right. Ma'am, are you under the influence of any medications, alcohol or drugs today?
Only one I was prescribed.
All right. And does any of the medications that you're prescribed, are they associated with your having a stroke in the past?
Yeah, we have those to go.
All right. Do any of them alter in any way your thinking or your ability to comprehend?
I don't believe so.
All right. Do you now, have you ever been diagnosed with any type of mental health difficulty?
Yes, I have PTSD.
All right. Do you take medication for that?
No.
Okay. Are you in treatment?
I talked to a therapist.
All right. So yes, you're in treatment. Okay. Are you presently under any type of probation or community control supervision in this or any other state?
No, ma'am.
Has anyone threatened, force or coerce you in any manner into entering into this plea of guilty today?
No, ma'am.
Has anyone promised you anything at all if you enter into this plea of guilty today?
No, ma'am.
Are you making this plea of your own free will?
Yes, ma'am, I am.
Now, the state has indicated that it is the expectation that you will enter a guilty plea as charged in the indictment to the single count indictment, aggravated possession of drugs, a felony of the 5th degree. Is that what you talked with Mr. Greenberg about today before this hearing?
Yes, ma'am.
Do you have, have you had an opportunity to review this 3-page plea form?
Yes, ma'am.
Do you understand what it says?
Yes, ma'am, I did.
Did your attorney answer all your questions about it?
Yes, ma'am, I did.
Do you have any questions right now about it?
No, ma'am.
All right. Ms. Thurston, do you believe that you've had enough time to fully consult with Mr. Greenberg about your entire case before this morning?
Yes, ma'am.
Has he answered all of your questions to your satisfaction?
Yes, ma'am.
Have you had an opportunity to review the evidence that the state has against you with your lawyer?
Yes, ma'am.
Madam Prosecutor, would you please put on the record whether or not the state has provided all discovery evidence, including any Brady material evidence, if any? You acknowledge the same?
So,
Ms. Thurston, are you satisfied with your attorney, Mr. Greenberg?
Absolutely.
Ma'am, do you understand the charge against you, aggravated possession of drugs and felony of the 5th degree?
Yes, ma'am.
Do you understand that if you plead guilty to this offense, you are making a complete admission that you committed the allegations contained in that indictment?
Yes, ma'am.
Do you understand that if you plead guilty, the court may enter a judgment of guilt against you and proceed to sentence you immediately?
Yes, ma'am.
Now, this being a felony of the 5th degree, do you understand that you are facing between 6 and 12 months in prison and up to a maximum fine of $2,500?
Yes, ma'am.
Do you understand that if I were to sentence you to prison, upon your release from prison, you could be on post-release control for up to 2 years?
Yes, ma'am.
And if you violate the conditions of post-release control, you could be returned to the institution for a total of up to 1/2 of your original sentence. Do you understand?
Yes.
Are you on post-release control right now?
Absolutely not.
Well, do you understand that if you are in post-release control and you're convicted of a new felony offense while in post-release control, that in addition to being punished for the new felony offense, the sentencing court could add an additional consecutive 1-year prison term or whatever time remains in your post-release control time, or whichever is greater?
Yes, ma'am.
Also, since this is a felony of the 5th degree, community control is a possibility, that's probation. Do you understand that I can place you on probation or community control for up to 5 years instead of sending you to prison?
Yes, ma'am.
And do you understand that if you are placed on a community controlled sentence, you will have to abide by all probationary conditions as established by this court?
Yes, ma'am.
And if I place you on community control and you violate the conditions of community control, you'd be brought back before me for a more restrictive sanction, or that can include a whole host of penalties. But the most severe penalty could be imprisonment up to 12 months, as I previously stated. Do you understand?
Yes, ma'am.
Also, if I impose court costs and you fail to pay those court costs, I could order you to do community service instead of paying court costs. Do you understand that?
Yes, ma'am.
You have any questions so far?
No, ma'am.
Ma'am, when you plead guilty, you give up some very important constitutional rights that I need to make sure that you understand. Do you understand that you have a constitutional right to have a trial, either to the court or to a jury of 12 persons?
Yes, ma'am.
Do you understand that you have a right to confront witnesses here in open court and have them cross-examined by your lawyer?
Yes, ma'am.
Do you understand that you have a right to have witnesses subpoenaed to come to court and testify for you?
Yes, ma'am.
Do you understand that at trial, it's the obligation of the state of Ohio to prove your guilt beyond a reasonable doubt?
Yes, ma'am.
Are you okay?
Yes, ma'am. My computer is working.
Oh, okay. We're gonna get you done in a few minutes. Do you understand that at trial, you cannot be forced to testify against yourself?
Yes, ma'am.
Do you understand each of these rights as I explained them?
Absolutely.
Do you have any questions about your constitutional rights?
No, ma'am.
Do you have any questions about anything we've discussed today?
No, ma'am.
Do you understand that if you plead guilty, you are waiving or giving up all of these important constitutional rights?
Yes, ma'am.
Ms. Thurston, knowing everything the court has discussed with you today, do you still wish to enter a guilty plea as charged to count 1, aggravated possession of drugs, and felony with 53?
Yes, ma'am.
Counsel, is there anything further before I accept the plea?
Nothing further.
All right, and you're stating the facts?
Judge, the memories of Audrey Thurston on or about the 20th day of January 2022, Hamilton County, State of Ohio, knowingly obtained, possessed, or used a Schedule II controlled substance to methamphetamine in an amount that was less than the full time.
All right, Ms. Thurston, do you hear what the prosecutor said you did?
Yes, ma'am.
Is it true?
Yes, ma'am.
What is your plea to count 1, aggravated possession of drugs?
Guilty.
Let the record reflect that Ms. Audrey Thurston is present in court with her attorney, Mr. Greenberg, and that Ms. Thurston was informed of all of her constitutional rights and has made a knowing, intelligent, and voluntary waiver of those rights. The court finds that Ms. Thurston understands the nature of the charge, the effect of the plea, as well as the maximum penalty which can be imposed. At this point, while I do find your plea to be voluntary, I am going to hold in abeyance the conviction. You understand?
Yes.
I'm accepting your guilty plea, but I'm holding the conviction in abeyance at this time. I'm not making a finding of guilt. Now, if you have any violations of the terms I'm getting ready to tell you about, then I will impose the conviction, issue the conviction. Do you understand?
Yes.
And then we will proceed to sentencing. Do you understand that?
Yes, ma'am.
All right. So I'm going to stay the proceedings at this time. An entry will be prepared by the court granting the motion for intervention in lieu of conviction and ordering Ms. Thurston to participate in an intervention plan under the supervision of the probation department. And these are the conditions. First of all, your intervention plan will be for 1 year. That's 1 year from today. So I'm going to set a date to make sure that you complete everything by 1 year today. You shall abstain from the use of illegal drugs and alcohol. You shall participate in treatment and recovery support services as recommended by probation. You shall submit to regular random drug and alcohol testing as provided by probation. And I'm not going to give you any community service hours today or there's no restitution. Do you understand those terms? So, and stay out of trouble. I do. All right. Sorry. No, it's okay. So let's go ahead and get a date for review. September 12th. 2023? All right, 1 year from today, September, you said October? September. This is October. Oh, we're in September, I'm sorry. September. What day of the week is that?
Tuesday.
Can we do the Monday? September 11th, 2023, 9 a.m. All right? So that's when I'll expect that you're completely done and this case will go away. Now, sometimes people are finished early and I will consider terminating everything if you finish everything early and do that. Okay? All right. Is there anything else, counsel?
Nothing further.
All right, I will need an execution of waiver of speedy trial, just to.
Yes, of course.
you'll do that now, have a form, and here's how we do it, client sign when you're done. All right, and then, anything from the state? Anything from the state?
Judge, this gentleman works at the nursing home and he is just wondering if she's going to have to report to probation or if she's going to be getting transportation or how will that?
Yeah, she should go there now, but in the interim, I'm not sure, they'll figure that out. Especially given her situation. Okay, thank you for asking that question. All right, I wish you well, Ms. Thurston.
Thank you.
We just need to, we're gonna need to see trial over here, I see that and then we're done.
Okay. Yes, thank you very much.
Or do you need to accept me?
No, it's for us. Yeah. Do I need to do anything special? Oh, I can look it up real fast. Can I take that back right there?